Hi, I'm Amaa Ollennu. Often people call me Nee. I practice with the NO law firm here in McKinney, Texas, in the Dallas-Fort Worth area. We primarily practice in Collin County, Dallas County, and Denton County. We do also provide services around the area and throughout the state of Texas. Primarily, we practice and assist clients in DWI cases, but we also have a general criminal defense practice. I've been licensed in the state of Texas for about 7 years. Opened up NO Law Firm back in 2015 after passing the state bar. And we love serving people in the community. It is our goal to provide information and help those who truly need it because the criminal justice system can be a very unforgiving entity. And for that reason, we are committed to making sure that our customers and our clients can truly understand what they're facing and have the best defense and have someone who will truly care about their interests, their needs, and their overall objectives and help them beat their cases. You can find us on our website, naolawfirm.com, and we can also be found on the Texas Legal Directory. Texas Legal is a statewide nonprofit legal benefit plan that was founded by the State Bar of Texas to better meet the legal needs of Texans. Texas Legal provides members access to over 400 network attorneys, and Texas Legal offers various insurance plan options. Contact information for Texas Legal will be in the description of this webinar. Please contact Texas Legal for more information on plan benefits. So it's important to remember when it comes to DWIs that every situation is going to be different. So it's best to consult with an attorney who specializes in criminal defense and preferably one that has a proven track record when it comes to DWIs and DUI defense. There are many factors that could play into each case because of the facts or the circumstances that surround it. Therefore, generalizing such a broad subject is very difficult. So please remember that today, this information is primarily for general purposes. If you need specific information relating to your DUI or DWI case or the process, please feel free to reach out. This is only provided so we can shed some light and provide some information to a very, very broad topic. What do you do if you're pulled over in the state of Texas, whether you're drinking or not, and you suspect you may be currently under investigation for driving while intoxicated or DUI? The basic concept that we try and tell our clients and any individual that I speak with is remember no ABCs. We want to make sure that there's no admission of any drinking. Now, that does not mean you need to lie. Lying is something you don't want to do because if we have to go to court later, that will look bad on you. So the best thing to do is not admit, not answer any questions without speaking with your attorney first. Second, you want to make sure you are not doing any battery of tests or do the battery of tests. The battery of tests are commonly known as the standard field sobriety test. And these tests are designed to, they say they're designed to detect intoxication. However, there are a number of issues with these tests and their administration. But it's best if you don't do these tests because participating in these tests, oftentimes, whether intoxicated, completely sober, some people just cannot complete these tests. And some officers aren't trained correctly, so they can't make the proper judgment call. And that means that you're going to be going to jail because of a faulty training process if an officer isn't aware of what clues actually are clues or what other factors may be causing you to display the clues that the officer believes that they see. The third part of that ABC is no consent. Do not consent to a blood test. Do not consent to a breath test. The reason for this is pretty obvious, but all of these, it all goes down to your Fifth Amendment right not to incriminate yourself. So play your part not to incriminate yourself, and that can help on the back end when you do hire an attorney and have to fight these charges. Overall, you must remember to consult with an attorney after your arrest. Most time during the process, you're not going to be given the opportunity to speak with an attorney. And oftentimes asking for an attorney is going to be met with some kind of resistance from the officers, and they may not want to give you that opportunity. They're not required to, but remember, always say, I do not want to answer any questions without the presence of my attorney. Likely, you will go to jail because the officer believes at that point in time they have some information to believe that you're intoxicated. However, your case will be a lot in a better position to combat a bad conviction or a bad arrest because of the fact that you did not incriminate yourself. Oftentimes, people end up being convicted because of what they say or what they do. Another thing that it's important for people to realize is that during investigation, always be respectful to police officers. Be mindful of the fact that everything that you're doing is going to be on camera and will be shown to a jury. And your best chance of success, even if you did everything right, can go down the drain if you're rude or abrasive towards police officers. They have a job to do as well, so always be respectful of them when engaging with them. And that typically is what I advise people to do if they've been pulled over, whether drinking or not. Now, a few pointers to determine whether or not your stop on the side of the road is related to DWI or is turning into a DWI arrest. You should listen for certain phrases and words. If an officer asks you about drinking, what do? We don't admit to any drinking. We don't discuss drinking. And that includes not discussing where you're coming from. If you say you came from a restaurant, an officer may decide to believe that that is a bar instead of a restaurant, and boom, now they have the ability to say that you were at a location that served alcohol, and the officer maybe smelled alcohol on your breath. That gives them enough. So that goes to the admission and making sure you're not admitting anything related to alcohol. Also, be very, very cognizant of the fact that an officer must limit the stop of your vehicle to the purpose for that stop. So if you're pulled over because you didn't use a turn signal or you have traffic or you have a light out, just remember that that stop is limited to that unless they get additional information to make them believe that some other crime is occurring. Then they can continue to detain you. So that's why it's important to remember not to admit anything. The battery of tests will come second, and that's when they ask you to step out of the car. Always make sure to be respectful, follow their instructions, step out of the car, but respectfully decline to participate in these tests, especially if you've had even just one drink, because officers typically hear from every person they pull over, from the very intoxicated to the people who haven't had anything or had one, they always hear, I had a drink or I had a few beers. So if you literally had a few beers, when the officer hears that, they're thinking this person had at least 5 or 6. So keep all of that in mind. Be respectful. It is a lot, and that's why it's good to have an attorney get involved in the process. But always be sure to be respectful and remember no ABCs. So what happens after you've been arrested for a DWI in Texas? In Texas, whenever you're arrested for a DWI, a few things happen immediately after your arrest. You're read what's called the statutory warnings, and these statutory warnings are actually designed to inform you of your right to decline giving consent for a breath or blood test. These warnings are frequently called DIC 25, and in that form, it'll show what blood test or breath test was requested from the officer and also whether you consented to these tests. Immediately after these tests, you'll likely go get your blood tested or do a breath test at the police department. Following that, you will get a judge to grant you a bond and read you your charges. At that point in time, you have the right to request an attorney and do a bunch of other fun things and figure out how to get out of jail so you can start trying to combat this case. Now, once you get out of jail, there's a few things that you need to look at and worry about. First, we need to look at that license suspension that could possibly come. If you refuse to give consent to a breath or blood test, your license can be suspended, but that is not a foregone conclusion. So you have what's called an administrative license revocation hearing. And that ALR hearing pretty much is an opportunity for you to question the officer on the grounds for the stop, as well as the basis for believing there's probable cause or reasonable suspicion to continue a DWI investigation and further make an arrest for that. After the ALR decision comes through, either your license will be suspended or your license may also not be suspended by the administrative judge. And based on that decision, if your license is suspended, you will need to get an occupational license or not drive during that period of time. After the administrative license phase, and sometimes it interacts or goes tandem with the criminal case, a criminal case will be filed against the individual who was arrested for a DWI. And in that case, you'll either have an information filed against you or an indictment. An indictment is filed on an individual who has a DWI that is a felony, and information is filed in a case where an individual is charged with a DWI that is a misdemeanor. And so just generally speaking, DWI third or DWI with an enhancement such as with a child passenger, or even if you were to get an accident and have vehicular manslaughter or intoxication assault, these are all cases that may be filed as a felony and an indictment may have to come through. And then there are other cases such as DWI first, DWI greater than 0.15, or DWI second. Those are going to be filed generally as misdemeanors in the state of Texas. So what are the typical costs of a DWI? Well, of course, there are attorney's fees, but fortunately with Texas Legal, they do cover attorney's fees. But there are some other expenses and costs that are associated with getting a DWI arrest, even if you aren't convicted. When you get arrested for a DWI, some of the costs you need to consider are the fact that your car may be towed, so you need to pay towing and wrecking fees. You'll need to pay a bond. Typically in this area, you're looking at a bond anywhere from $500 to $2,500 for a DWI first. And if you use a bond company, that means you're usually putting down approximately 10% to pay that bond company so that you can be released from jail, or you can pay that money up front to the court. And then when your case is disposed of, minus the administrative fees that the county takes out, you will get that money back. Other costs associated are going to be a super fine. So in Texas, the super fines range anywhere from $3,000 up to $6,000. For DWI first, you're looking at $3,000. For a DWI second, within a certain period of time, you're looking at a $4,500 super fine. And for DWI or greater than 0.15, you're looking at a $6,000 super fine. Other costs are going to be including, we have court costs, we have fines. Court costs are a cost that is imposed by the court whenever they file a case, whenever they have to serve subpoenas. That cost is set, and there's not much that can be done to avoid those. In some cases, for individuals who are indigent, that can occur. Most of the time, though, those costs are fixed. When it comes to the fines, those are usually handed down either by the judge or by a plea agreement. You can come to an agreement on the amount of the fine, and those are the fines I mentioned earlier. Other than that, you also need to be cognizant of the fact that you have to miss work to go to court. You're looking at least 2 to 3 court appearances. Some cases, there may be more depending on the court you're in, if they require personal appearances. Some courts here in this area allow individuals to not come to court each and every time if they have an attorney representing them and the attorney is present. Another cost that is associated not only with pre-trial, but also if you're convicted or put on deferred probation after DWI, are the interlock requirement, the classes, and also the drug testing. So while you're on pre-trial release for a DWI, you also need to consider the fact that you will most likely have to have a deep lung device in your vehicle. Most jurisdictions have this as a standard condition of the probation and pre-trial release to make sure that you're not drinking anymore. If you do violate these conditions, it could impose additional sanctions or additional costs. So be aware of that. But these are some of the biggest costs associated with DWIs, because you're looking at probation fees, approximately $60 a month. It could fluctuate. And you're also looking at that intoxilizer in your vehicle. Sometimes you have to have a scram device or a home device. And these are going to be monthly subscriptions, approximately $100 a month In some cases, it could be a lot higher. So these are all recurring costs, and they last throughout the duration of your pretrial release until there's a disposition in your case. And then if you're on probation, those conditions will apply further. And so these costs, you can see, can easily add up. So what are the differences between a DWI first and a DWI second? So DWI first is going to be charged as a Class B misdemeanor typically, and DWI second will be charged as a Class A misdemeanor. With a DWI first, the reason I say traditionally or commonly charged as a Class B is because there is one enhancement that will elevate your Class B misdemeanor up to a Class A. So if you get a DWI first with a blood score greater than 0.15, then that'll ultimately be charged as a DWI greater than 0.15 and be a Class A misdemeanor. The range of punishments for these two offenses is going to be different. You're going to have, on a Class B misdemeanor, you're looking at a range of punishment for a DWI first, anywhere from 3 days in jail up to 180 days in jail, anywhere from no fine up to a $2,000 fine, or both. Conditions of probation would also be a little different. Conditions of probation would include a victim impact panel, as well as some community service and some other classes and alcohol abuse evaluations. With a DWI second, you're looking at a Class A misdemeanor, and that range of punishment is going to be anywhere from 30 days in jail up to 1 year in jail, and a $0 fine up to a $4,000 fine, and or both. The probation conditions for DWI second are going to include a lot of the similar conditions as the DWI first, except there will be a repeat offender DWI course. And these are not only required in the criminal setting, but to get your license back, ultimately, you will have to complete these courses to get your license back after the suspension or the conviction has gone away. You're also looking at possibly different suspension times and requirements, as well as the ability to get a non-disclosure. With a DWI first, you do have the ability to get a non-disclosure and also deferred adjudication, which means that ultimately, if you successfully complete that probationary period, your DWI will not consist or will not be considered a final conviction. And that's also the case with some out-of-state DWIs. So if you happen to get another DWI here in Texas, that DWI may not necessarily be considered a second offense because there's no prior conviction of that. And so the DWI second offense requires that you have a previous conviction for DWI or DUI in the past, depending on what the state you are in when you got that initial conviction considered that offense. Thanks again, everybody, for listening in. Again, I'm Amaa Ollennu with the NO Law Firm here in McKinney, Texas, serving the Collin County and Dallas County and Denton County areas. So if you need any assistance, please feel free to give us a call. Please also make sure to reach out to Texas Legal and hear about their plans. And hopefully you don't need us, but if you do, please give us a call. We'll welcome you like family. Thanks.